is an employee who wants to resign her job, duty bound or legally bound, to serve a notice of termination or a notice of resignation to his or her employer before she or he can resign. You want to resign your job and go to your next employer, but you are wondering whether the requirement of notice or the requirement of paying in lieu of the notice of termination applies to you. The new employer wants you to go to work immediately. Your old employer is not willing to release you immediately and is demanding that for you to be released from employment, you have to serve a 3 months notice, or you have to pay 3 months wages in lieu of that notice. So you are torn between leaving without notice and having to take a loan to pay in lieu of the notice, or just abandoning the new job because you cannot meet the contractual requirement of notice. Is an employee who wants to leave her employment by way of resignation, or an employee who is willing to terminate her contract of employment, legally bound to give the notice of termination of the employment contract. Now, before I take you deep into the issue of notice, I want to explain a concept of law that is very, very, very important for the determination of whether or not an employee is legally bound to give notice of termination or to pay in lieu of notice of termination to the employer. Now, that important concept lies within the words of Section 27 of the Employment Act. Section 27, subsection 1 of the Employment Act is to the effect that where a contract of employment excludes any provision of the Employment Act, the entire employment contract is null and void and is of no legal effect. So, under the law, the Employment Act forms the bare minimum of the employment conditions that must be ensured by every employer. In short, an employer is by law bound to meet the provisions or the rights of the employee as provided by the Act as the bare minimum. As the bare minimum. An employer is legally disallowed or is legally prohibited from undervaluing the provisions of the Employment Act with regard to the rights of an employee. So, if any provision of the employment contract goes below the minimum standards of employment provided by the law or by the Employment Act, that employment contract is null and void and is of no legal effect. Now, by interpretation, the courts have taken a more liberal view and have actually held that where there is a provision within the employment contract that abrogates in any manner the provisions of the Employment Act, then that provision is null and void. It's a more liberal view because rendering the entire contract of employment null and void itself has very serious consequences, and it renders the employment relationship itself problematic. Now, Section 27, subsection 2 allows an employer to give terms of employment that are better than those provided by the law. In short, an employer can give terms of employment to an employee that are much better than those minimum standards provided by the Employment Act. But he is not allowed to give terms that are worse than those which are provided by the Employment Act. Therefore, if an employee is given terms of employment that are in any way worse, than those that are ensured by the Employment Act, then Section 27 of the Employment Act comes into play. Now, I believe everyone has understood the import of Section 27, subsection 1 and subsection 2 of the Employment Act.